Welcome to This Explainer. Today, we're diving straight into a fascinating landmark Supreme Court case all about bigamy and void marriages. We will be methodically breaking down the comprehensive text of Luisito G. Pulido versus the people of the Philippines under GR No. 220149.
Here's our agenda for today. We'll be moving step by step through 1. Facts, 2. Issues, 3. Ruling, 4. Ratio decidendi, 5. Doctrine or principle, and finally, 6. Disposition. Let's kick things off with part 1, the facts. The timeline of events here is honestly so interesting. It starts way back on September 5th, 1983, when Luisito Pulido married Nora Arcon under the old civil code. Then, jump ahead a dozen years to July 31, 1995. Without that first marriage being legally dissolved, Pulido contracts a second marriage, this time with Rowena Belmida under the newer family code. Fast forward again, and following a betrayal, Nora Arcon actually files bigamy charges against Pulido in 2007.
But here is the massive twist in the story. A trial court later issued a decree of absolute nullity of marriage regarding that first 1983 union. Why? Well, because a valid marriage license was literally never issued. A certification from the civil registrar confirmed that no entry for a marriage license or license number actually appeared on their record book. Because it was completely absent, that first marriage was officially declared void ab initio. So that brings us right to part 2, the issues. The court had to tackle 3 very specific legal friction points. First, whether Article 40 of the Family Code applies to the instant case, considering the different governing laws for the 2 marriages. Second, whether a judicial declaration of nullity of the prior marriage as provided under Article 40 of the Family Code may be invoked as a defense in bigamy cases. And third, in the affirmative, whether a judicial declaration of nullity of marriage secured after the celebration of the second marriage should be considered a valid defense in bigamy cases. All right, let's look at part 3, the ruling. The Supreme Court actually ruled in the affirmative, and in doing so, they explicitly abandoned their earlier jurisprudence. That's a huge deal. They firmly held that a void ab initio marriage is a valid defense in the prosecution for bigamy, even without a judicial declaration of absolute nullity. Basically, a judicial declaration obtained by the accused, no matter when it's secured, absolutely counts as a valid defense. Now, let's unpack the logic in Part 4, the ratio decidendi. To really understand the court's reasoning, we have to look at the exact wording of the law. Under Article 349 of the Revised Penal Code, a key element of bigamy is contracting a second or subsequent marriage before the former marriage has been legally dissolved. That exact phrase, legally dissolved, is absolutely critical here. The court highlighted a really severe contrast in legal concepts. Think about avoidable marriage versus a void ab initio marriage. Avoidable marriage is completely valid until it gets annulled. It actually needs a dissolution. But a void ab initio marriage, it is inexistent from the very beginning. To all legal intents and purposes, the parties were never married. There is literally nothing to dissolve. So Article 349, with its requirement of a marriage being legally dissolved, strictly contemplates valid or voidable marriages, definitely not void ab initio ones. On top of that, the court leaned heavily into statutory construction. Criminal law is guided by some strict, non-negotiable principles. Penal laws have to be strictly construed against the state and liberally construed in favor of the accused. There's also the principle of in dubio pro reo, meaning when in doubt, rule for the accused. Yes, Article 40 of the Family Code requires a judicial declaration of nullity to remarry, but it doesn't explicitly deny the accused the right to invoke a void ab initio marriage as a defense in a bigamy trial. If the court ruled otherwise, they'd be interpreting the law way too liberally in favor of the state, which goes against fundamental criminal law principles. Which brings us to Part 5, the doctrine or principle. If you take away just one thing from this digest, let it be this. A void ab initio marriage is a valid defense in the prosecution for bigamy, even without a judicial declaration of absolute nullity. You don't have to get a judicial declaration of absolute nullity of that first void ab initio marriage just to use it as a defense in a bigamy case. Article 40 of the Family Code didn't amend Article 349 of the Revised Penal Code, so the accused absolutely still has the right to collaterally attack the validity of a void ab initio marriage during a criminal prosecution. Finally, let's wrap up with Part 6, the disposition. Because there was no valid prior marriage to begin with, the Supreme Court's final action was clear. The petition is granted. The CA decision is reversed and set aside. Petitioner is acquitted. Since that 1983 marriage was missing a valid license, the most essential element of the crime of bigamy, which is a prior valid marriage, was completely lacking. The prosecution simply couldn't prove the crime was committed, so Luisito G. Pulido was fully acquitted.
As we finish up this explainer, I want you to think about how strictly applying these legal definitions actually protected the accused from an overly broad interpretation of criminal law. Does requiring a separate judicial declaration for a legally non-existent marriage unjustly expand the scope of criminal liability? Well, the Supreme Court decided it definitely does, firmly upholding the strict construction of penal laws. Thank you so much for joining me today to break down this fascinating case.